Good afternoon and welcome. I am Tyson Yvonne, Advocate Support Program Manager here at Standpoint. I will be facilitating today's webinar, Who is Who in Family Court. Presenting is Amy Eisner, our Senior Staff Attorney. Should you have any questions during her presentation, please type it in the Questions tab of the control panel, and I will present the questions to Amy as they come in to answer them. In the chat box, I have already uploaded the PowerPoint that she will be using today. Feel free to go ahead and save that or print it out so that you can follow along. If you can't open up that link, let me know, message me, and I will try to problem solve that with you. Another thing is, as always, this webinar is being recorded and I will upload it to Standpoint's YouTube page in the following week. We have many more helpful webinar recordings on our YouTube page for you to listen and view when it's convenient for you. Our webinars are prepared specifically for advocates. As we're wrapping up 2019 webinars, I will be sending out a link to a survey for the 2020 webinars that we will be starting in January. So if there's topics and things that you would like us to present on or that you would like more information about, definitely fill out that survey when I send it out onto the listserv, and hopefully we can honor some of those. Another thing is, if you have not subscribed to a YouTube channel, go ahead and do that so that you can get notifications when we upload videos. That's all I have for now, Amy. I'm going to pass the mic on over to you.
Great, thanks, Ty. Hi, everybody. Welcome and thanks for tuning in for this discussion about all the different players in family court. My name is Amy Eisner. I'm the Senior Staff Attorney here at Standpoint. And just for those of you who don't know, Standpoint is a statewide organization in Minnesota. We're a nonprofit program, and we provide legal advocacy and legal advice over the phone to victims of domestic or sexual assault, the advocates that work with them, attorneys who represent them, and other players who are involved in their legal lives. So we have several different attorneys, all who have different areas of expertise. So if you need legal advice, feel free to call us anytime. Our advocates are also have specific areas of expertise, but are happy to provide advice and advocacy to victims and to all you advocates out there. Another thing we do here is provide trainings. We travel through the state one time a year doing our annual new laws training, where we update advocacy about all the different case law that came down from the Court of Appeals and Supreme Court, and also statutory changes that affect our clientele. So today what we're going to talk about is the different professionals that can become involved in a family law case. It can get really confusing. They have similar names, but all have different roles. And so it's even after practicing family law for many years, it's still confusing to me. So we'll walk through who those players are and what they do and how they can be of service and support to our clients. So here we go. Just as a preliminary issue, an overview of the family court. What family court is a division within the district court. So we have federal court and state court, and part of our state courts are divided by districts. And in your district, there will be a main district court, and family court is one of the divisions that is within the district court. They primarily deal with issues that affect families and children. So the most common kinds of cases that we're talking about when we're looking at what family court is going to include orders for protection. Those are a family court order, even if the parties were never married or don't have children in common. If it was an intimate partner or household relationship, it still constitutes a matter that falls under family court. Divorces, which are legally called dissolutions, are also handled in family court, as well as custody issues, whether within a marriage or outside of a marriage. Parenting time can also be addressed, which we often call visitation. Child support, so how much money the primary parent is going to receive from the other parent to help provide for the child. And paternity, which is legally called parentage, whether the person even has a right to ask for custody or parenting time with the child. And we'll talk about that a little bit more in a minute. The final thing that's most often heard in family court is visitation, or third-party custody. If grandparents, adult siblings, or other people want to have parenting time with a child that they've previously lived with or had a significant relationship, family court is the arena where they would ask for that. So there's several different court actions that can be filed and started in family court. So the first question that a judge is going to consider is whether the party even has a right to ask for custody. And the Minnesota Parentage Act recognizes who has the right as parents under the law. If the parents of the child are married, each parent has equal rights to the custody of that child. Under the Act, a mother who is not married to the father or not married at all has sole custody, both physical and legal, of that child. If the man has not been acknowledged by the court to be a father through a paternity action, then the mother has sole legal and physical custody until the father takes steps to establish that. A paternity action gives men the ability to be legally acknowledged as fathers, to be legally adjudicated, which means that a court makes a finding and order that they are the legal father, and provides some rights to men who have signed recognition of parentage or ROPE forms, which is an affidavit signed by both parents that verifies the man is the father of the child. The father can ask for custody and parenting time during a parenting procedure, or after paternity is established, they can do so by seeking custody through the family court statutes, which is Minnesota Statute 518. So the first step in a paternity action is to determine if the man is indeed the father of the child. The parents can agree that he is the father, or the court can order blood testing to determine whether or not he is. According to Minnesota statute, if the father of a child has signed a ROPE, he is considered to be legally adjudicated. So adjudged, found to be the father of the child. The signed recognition of parentage gives the man the right to forego blood tests and be directly adjudicated, which means he can directly file for custody or parenting time. With his ROPE, he cannot request custody and parenting time in an OFP action, though. We often talk about how orders for protection can lead to unintended parenting time or custody adjudications, which we want to avoid. We've seen courts doing that, but it's not statutorily permitted just by having a ROPE. He would have to have a paternity proceeding action determine that he's the father to be able to ask for that in an order for protection. The only place he can do it is in a custody motion. So the father with a ROPE must file for custody under Minnesota Statute 518, and the family court will use the best interest standard, which is the list of 12 best interest factors that are listed in the statute to determine custody and parenting time. The statute forbids this process to be combined with any other action, including the Domestic Abuse Act. So that means a non-adjudicated dad should not be able to ask for custody and parenting time during an order for protection, even if he has signed a ROPE. But some judges get sidetracked from these issues. Custody and parenting time can only be given to fathers recognized by the court, and it's inappropriate to ask for custody and parenting time at the order for protection hearing unless the parents are married, or the court has previously adjudicated a dad as the father of the child. However, again, some courts have been giving ROPE dads custody or visitation at order for protection hearings, and so that's just something that we need to always be aware of and recognize. So the paternity court will, if you're married, you have joint physical and legal. If you're not married, there's ways to recognize the legal father. And paternity is kind of complicated, and there's lots of different presumptions and different people who can assert that they're the father. But the players that we're going to talk about can become involved in paternity actions, as well as divorce, custody, and order for protection hearings. And so I just wanted to point that out here. So always looking back to how advocacy and how this affects you and how you can best serve our clients. Advocates should always create and continue to develop relationships with local attorneys because these relationships help battered women receive legal advice and find further representation. We're not able to have personal relationships with all of the players in your specific communities since we serve the whole state. But as you work your cases and as you represent clients in finding attorneys and in finding appropriate help through other services, those relationships are always the most important, and we can't stress enough how good it is to have relationships with all the players in your community. So in order to prepare women for the family court process, it's important that we provide them with all the information that they need to feel supported and ready to go through the process. So it's important for you to know the knowledge of how the family court process works and to be able to explain to our clients what they can expect on any given matter, because this can help them determine whether or not they're ready to begin to proceed through that process. And part of that, of course, is knowing who all these different players are, which is the point of today's webinar. So resources that you should always be aware of to be able to support your clients through family court is the legal services or legal aid available in your communities, the pro bono services or organizations or private attorneys who are willing to provide free legal advice, representation, and service to clients in your community. Private attorneys or law firms who maybe take clients on a sliding fee scale or on a basis where they can pay monthly or something. And of course, the pro se or self-help processes in your community, being able to know where to show them the family court documents online and get the right forms that they need. So that's just kind of the background. And now we're going to get into all the different parties and processes that can be involved in custody and parenting time matters. So dispute resolution is the court's way of attempting to have parties reach a resolution themselves without having a trial and the court making the decision for the family. I always advise my clients that yes, the judge is paid to make decisions and will advise you and the other party about they get paid the big bucks, right? They're going to make the decision. If you and the other party can't reach an agreement and it comes to a trial, they will make the decision for you. But they always say that parents know their children best and can prepare a best plan for their family much better than a judge who's going home to their own family. Not that they don't care, but they're not invested in it the same way that the parties are. So there's exceptions of who's expected to use these, and when there is domestic abuse determined either by an OFP or an HRO or a criminal case, if there's probable cause that physical abuse or threatened physical abuse against the parent or child has occurred, the court may excuse the parents from having to do this or may provide alternative ways to using a dispute resolution format, such as doing mediation in separate rooms and having the mediator shuttle back and forth between the two private rooms so that the parties aren't face-to-face or having to breathe the same air as their perpetrator. So parenting time dispute resolution is typically used for visitation disputes, whether that's ongoing or if you think there's going to be a problem in the future based on the current order. So it's available to parties to resolve such issues as enforcing, interpreting, clarifying, issues that aren't specifically addressed in an existing parenting time order, or making a change in it if there's actually been a violation of the order or it's just not going to work for the family anymore. If the parties have a parenting plan, the method of dispute resolution will be included in the plan specifically, but the parties can always select a different method for resolving their visitation disputes. Not everyone is required to use a parenting time dispute resolution process based on the 3 exceptions that we just talked about. And it's important to ask for a parenting time dispute resolution when there is a disagreement about visitation. They can be used for current disagreement, future anticipated disagreement if you think the other party is going to deny future parenting time or keep the child when they're not supposed to. When a parent is not exercising their parenting time, they're just not spending time with the child at all, or they're interfering with our client's parenting time. So that's the most common times when these professionals are needed. So who are the players? The players are typically a parenting time expediter, the guardian ad litem, a custody evaluator or investigator, mediators, parenting consultants, parenting coaches, and therapists that are involved in the family's life. So the next 3 slides are borrowed from the Minnesota Continuing Legal Education Board, which is for lawyers. They prepared a summary guide comparing roles in family court cases. And so I've provided these next 3 slides to you from their process. And we're on the left, you'll see the parenting time expediter, all of the roles that I just mentioned going down on the left, and across at the top is the specific information about the duties of each party. And so we're not going to go through this chart together. I just wanted to provide it to you as a resource. So the second page talks about whether they're a party or not to the action. If they are required to testify about the information they have, whether they can be called, whether they can be sued for not doing their job properly, whether they have the authority to make decisions and enforce it upon the parties, or whether they make recommendations and how they do that and who they make the recommendations to. And the third slide is about discovery, whether you can require them to provide discovery or whether they access discovery throughout the case, what limitations are set upon them, when it's appropriate to use them, and how their fees are determined or paid. So we're going to go through each one at a time, starting with parenting time expediters. So this type of dispute resolution uses a list maintained by the court administrator, meaning that the court has a list of parenting time expediters who have undergone 40 hours of family mediation training and have received a certified domestic abuse training and continue to receive 3 hours per year of continuing education about working with domestic violence cases. However, parents who are using dispute parenting time may voluntarily use a neutral third party whom they both agree to. Under the new rules, guardian ad litems are specifically prohibited from being a parenting time expediter on a case that they are also the guardian ad litem on. So guardian ad litems may have a side business where they are parenting time expediters, and it's fine to use them as long as they're not the guardian ad litem on your own case. So the parenting time expediter makes decisions on the dispute, much like a judge. The expediter's decisions are binding on the parties, but a judge can still modify or vacate the agreement. So expediters can be removed from the case when good cause is demonstrated, for example, if they're being biased or not cooperating, not participating when you're calling them and needing them. So a judicial officer, which is a judge or referee who practices in family court, can order a parenting time expediter to the case without the parties agreeing to it or asking for it. It can be a requirement that is set up for future problems if they're not able to agree after the final order has issued in a custody or divorce hearing. So the duties of the parenting time expediter are defined by statute and court order. It's a mediation or arbitration process to enforce, interpret, clarify, and address parenting time circumstances that aren't specifically addressed by the existing order, and to determine if the existing order is violated. So they a family may either agree specifically in their divorce or custody order, or a court may order a lot of specific things about what custody, parenting time, visitation, holidays, exchanges are going to look like. But there are going to be circumstances that are going to come up that can't have been predicted or ordered in the original order. And so the parenting time expediter's role is to set an order or set the requirement when something like this comes up after the final order is issued. They can interview the child if there's a court order that they can do that, or if the parties agree that they can do that. It's important to recognize that they are a mandated reporter, so our clients may for sure need to know that before they're talking with the parenting time expediter, to be aware if they want information to be shared with them that could lead to a mandated report. So the parenting time expediter is not a party to the matter, which means that they can't file motions, they can't intervene or participate in if the matter goes back before the judge. There is a statutory prohibition that you cannot subpoena them or call them as a witness if you go back to court because there's a disagreement about the parenting time or custody, or it needs to be modified. And they are immune from civil liability, which means that you can't sue them for making a decision or not making a decision that you don't think is best for your family or the children. So their role and their decision-making power is to enforce, clarify, or interpret prior orders, and their decisions are binding, which means that if you go before them, so you've had your final divorce or custody order, something goes wrong, you're ordered to use a parenting time expediter, you go to them and say, we disagree about how to interpret this language in the order. Once they make a decision about how that's to be interpreted, both parties are required to follow that, unless the only way to not follow it is to go back to court and have the court then make an order, or to either clarify, interpret what was intended when the court made that specific order, or to ask the court to change it. So their role is not to make future recommendations or to decide how new things should be in place. They're quite limited under case law. Their role is really to interpret for the parties what was intended in a prior order. So the parenting time expediter has limited discovery. The statements made to them and documents that they hold are confidential, and excuse me, they're confidential unless all the parties and the parenting time expediter agrees that it can be used in court, or the parenting time expediter may include reasons for their decision in a document that can be used. So example, we don't agree with what the parenting time expediter said. We can bring this decision that they made to the judge and say, this is why they decided it. This is why we disagree with it. So they are limited to schedule and access issues, which means they can't just go get any private documentation about the family. And they can't make a decision that's inconsistent with the court order unless the parties agree. So if the parties agree to anything, you can pretty much agree to anything through any of these professionals, but they cannot impose something upon you that you don't both agree on that are inconsistent with the prior order. So it's appropriate to use a parenting time expediter when the parties need help making decisions on a relatively quick basis. So if you have filed a motion to resolve something for the long term, a parenting time expediter might make a decision for the short term that the parties will agree to follow pending the resolution. So they're used post-divorce or post-custody or parenting time order. Once your final order has issued, they're typically used to interpret that order. They're not used to help settle an order or move forward. And it's most oftentimes on a one-time dispute. It's not on an ongoing issue regarding visitation. It's a, oh, we didn't think of this when we drafted our original agreement. What should this really look like? We'll let the parenting time expediter decide and we'll go with that. If we can't agree with that, then we'll file it with the court. And they are not free. Their expenses and fees are set by them or the court. So if a court appoints them and requires them, the court is typically going to let you know what the fee is going to be. Or if you hire them privately, it'll be set by the contract. So that's parenting time expediters. We will move on now to guardian ad litems. So guardian ad litems can be used prior to the final order, the opposite of a parenting time expediter. Guardian ad litems can be appointed by the court in orders for protection, custody, divorce, or parenting time motions and cases. So again, the parties don't have to agree. The court can do it, appoint them and assign them to the case without the parties agreeing. And they are governed by the Minnesota Rules of Guardian Ad Litem Procedure and through the Family and Juvenile Court Rules. Some guardian ad litems are appointed. Some appointments are not governed by the rules, but are set by other rules, which are too detailed to get into for today's purposes. A guardian ad litem is a mandated reporter. Again, always important to remind our clients that what that means and what impact that could have on them. So the duties of the guardian ad litem are defined by statute, rules, and case law. Their role is to be the eyes and ears of the court, essentially, and to advocate for the best interest of the children. They are often used in juvenile court as well, which is a very different role than they have here in family court, so we're not going to cover that at this time. Their role is to consider the child's wishes and to prepare and conduct an independent investigation separate of any other reports or players that have already made an investigation in the case. They present written reports, which the copies are provided to the parties prior to the hearings as well as to the court. The court is not bound to follow their recommendations. The court will always make their own recommendation, their own orders, but the guardian ad litems do make recommendations and advocate for what they believe is in the best interest of the child, of the parties. The guardian ad litem always meets with the child and does home visits unless they're specifically exempted from doing that by the court. Oftentimes in orders for protection, they may just have half an hour to meet with both parents and then make a verbal report to the court in an order for protection hearing, which I'm sure many of you have experienced. In a family court matter where it's a divorce or custody, it's usually a much longer process. They are given a timeline to conduct their investigation, meet with the child, hopefully meet with the child in the home, and consider the child's wishes prior to making their recommendations in a written report. In family court, they may be made a party to the case, which means that they have a right to all of the information. They are equal to the other parties. So mom and dad are each parties. The guardian ad litem can also be a party. Anytime the child is a party, the guardian ad litem will for sure be made a party. They have immunity, which is absolute per case law, as long as their actions remain within the statute and the rules, meaning they cannot be sued or held accountable for any decision or recommendation that they made, as long as they followed their role and done their duties. They have no decision-making power. They do not have the authority to tell the parents what they shall do. They can, however, help parties negotiate settlements and make recommendations which help the court make their decisions. So when they make a recommendation, it is based on what they believe is in the best interest of the child. And 518.17 has the 12 best interest factors listed out that the court needs to consider and make determinations about. They are not bound or limited to only those 12 factors. They can consider anything that they believe is in the best interest of the child in making a recommendation for what they think the court should order. Their notes, documentation, and information is limited as to what the parties can access. However, if the court orders it, their file is discoverable, which means that an attorney or a party can go and demand to see the guardian's file. But they will not share other people's information. So if they've gathered a report from the school and it's in their file, that's not discoverable. Only their file and what they've created is discoverable by the parties. Again, we talked earlier that if they are the guardian ad litem appointed to a specific case, they cannot serve as the parenting time expediter. And they're not to be used as a substitute decision maker in their guardian ad litem role. They don't make decisions for the parents or for the court that are binding upon the parties. So if there are allegations of child abuse, it is mandated that a guardian ad litem be appointed. Due to guardian ad litem financial issues over the last several years, them not having enough resources and money to support a guardian ad litem being appointed, the first place that they were cut was through family court. They're always used in juvenile court, which is child protection and termination of parental rights cases. As their funding is increasing again, I know that the programs are attempting to put guardian ad litems back in family court cases. And it can be very valuable to our clients when they are able to see the whole case. And it can also be harmful. We've had experiences with guardian ad litems doing a great job and other guardian ad litems not recognizing domestic abuse for what it really is, of the power and control dynamics and the coercive control that some partners have. So it can be important, again, for advocates to be meeting with guardians with their client to make sure that the guardian ad litem is understanding the full dynamics of the case. We know that abusers can be persuasive and charming, so they can cause confusion. Another time besides child abuse when a guardian ad litem is helpful is when the child's best interests aren't clear. Both parties may have really strong positions, but there's no endangerment or abuse or strong support on either side, and they can't reach an agreement. And they're super polarized, the father and mother, and so when the child's best interests aren't clear, a guardian ad litem can also be appointed in those kind of cases. We did talk about at the beginning that they're appointed by the judicial officer, but parents can also request them and ask that they be appointed at other times. The fee status is set by the guardian ad litem program or the court. If a party has a informa pauperis or a fee waiver for their case, typically the fees are set aside or lowered based on their income and their ability to pay, but they are not a free service, and oftentimes I think it's like $800 typically for the case that each parent is required to pay unless they can show an inability to pay. So the third group of professionals that we'll look at is the custody evaluator. And in my experience working as an attorney through family court, this was the most common and oftentimes the most valuable professional that was appointed to my cases. So oftentimes parties they go to the initial case management conference and are instructed to go do SENE, or a social early neutral evaluation, We're not talking about those people at this time. But those are the first step. That's when a male and female professional will meet with the parents together, and each parent provides their prospective preferences of what should be determined in the best interest of the child. The evaluator's job in a social early neutral evaluation process is to say, well, based on my experience and the information you've provided me in the last 3 hours, is that I believe a judge would order A, B, and C. And so A, B, and C then provides the starting point for the parents to negotiate based on what a professional thinks a court is most likely to do. A custody evaluator in a custody evaluation process is oftentimes the same professional, but it's a very different role. So the custody evaluators that I've worked with are after an SENE or a social early neutral evaluation mediation process has failed and the parties aren't able to reach an agreement, or when there's been a history of domestic violence and so that step is skipped over and a custody evaluation is ordered instead. The purpose of the custody evaluation is, again, for a professional to look at the family and make a recommendation of what they believe is in the best interest of the child and what the court should order. And so these are often ordered at the initial case management conference when there's been a history of domestic or abuse or assault. So the parties can request this step, or a judicial officer can order it without the consent of the parties and require that this is the next step prior to a pretrial and court trial being scheduled for custody or parenting time issues. So the duties of the custody evaluator are defined by statute, Minnesota Statute 518.167, if you want to look at what they specifically are. Their role is to investigate, report, and make recommendations regarding custody and parenting time, interview the child if it's age appropriate, have a home visit with the child, which is required unless they are exempted by the court or both parties agree there should not be home visits. And they are not in an advocacy role. Their role is not to recommend one parent over the other. It is to recommend what is in the best interest of the child based on their thorough investigation. So unlike the early neutral evaluation, which is typically half of a day process, this is often a 3-month process where the evaluator is having significant detailed meetings separately with each parent. They're seeing the child with each parent, preferably in the parent's home, but if there is a reason why the parent is only allowed to have supervised parenting time or something, they will have it in their office. Hennepin County specifically has their very own custody evaluators. They have a family court process on the second floor of their courthouse where SENEs can be held and where the custody evaluators work. So a custody evaluator is just appointed by the court. That person meets with the parents right away, sometimes even on the day of the ICMC, to have them do an initial intake packet. And then they will go through a very thorough investigation process and make recommendations. They are not a party to the case. They do have immunity, and their report automatically becomes part of the court's file. So they've done their evaluation, they submit their report to the court and to both parties. Oftentimes what then happens is at the pretrial is when the parties will have received the report and have had time to review it, and then they come to the pretrial with that report as a starting place again to try to resolve the case. Courts are not bound by the custody evaluator's report. They don't have to follow it, but it is very often the basis, the starting point for where parties can negotiate or where the court's going to start the trial from saying, okay, this is the recommendation, prove why it should or shouldn't be ordered. Also, their report does come in to the record typically on its own without having either party having to call or subpoena the custody evaluator as a witness. That's very helpful because it saves money if that's an issue. Either party can, however, subpoena and call the custody evaluator to cross-examine them about their report or to ask questions about why they made the recommendations or to prove that they're wrong, why they disagree with it. So again, they have no decision-making powers. Their report is a recommendation to the parties and to the court. And they can help to facilitate agreements, again, between the parties, much like they would do in an early neutral evaluation. But they don't have any authority to require the parties to do anything. In making their recommendations, they're basing it on the statutory 12 best interest factors. So their reports often go through those 12 best interest factors and have paragraphs explaining why they favor one parent over the other in each factor. So their roles for discovery is again defined by statute, and their report does come in as evidence, and other information that they've obtained can be discoverable by the parties. The limitations on them is that if one party does not participate, the file is closed. So even though the court can order the parties to participate in the custody evaluation, if one party just dips and doesn't want to talk to the evaluator at all, doesn't cooperate, won't provide documentation, the file is closed through the custody evaluator and they're not able to fulfill their investigation or make a recommendation. Again, the best time that these are used is when there's questions about the parents' abilities and emotional resources. How are they able to provide for the kids? Are there concerns about drug use, parenting use, parenting abilities, mental health, other concerns about the parent that needs more than a quick overview, that needs a more in-depth investigation. And again, their fee status is set by the court based again on informa pauperis or fee waiver forms. Parties who aren't able to pay are provided a lesser fee. Parties who are able to pay may be required to pay both parties' expenses, etc. And that's again determined by the court. The next professional is the mediators, who have a completely different role, and I'm going to take a break to take a drink of water. If there's any questions, now might be a good time to let me know that.
There isn't any questions so far, Amy, but if any of you listening in do have any questions, feel free to go ahead and type your questions in the question and answer tab there, and I will let Amy know. Or you can type your question in the chat box as well, and we can answer them through that.
Thank you, Ty. Let me just go back to the custody evaluator for a second. Generally, when both parties agree about custody, a custody evaluator isn't going to be needed. Sometimes, if the court doesn't have their own family court services professionals, county welfare agencies are utilized for determining custodial arrangements, such as mental health professionals, court employees, or even child protection workers. There are no statutory requirements about what kind of qualification a custody evaluator has to have, such as their training or information about domestic violence or anything. I referred to the reports that they write as custody evaluations, which is the most common form, but some counties call them something different. A mental health evaluation or a parenting evaluation are different and are done by professionals, typically in the mental health arena, and those are mandated, what kind of experience and training they have to have. But that's a little bit different than the custody evaluation and is pretty rare in a family court file. Those are typically used in juvenile court, but I just want you to be aware that a parental assessment or parental evaluation is something, but it's different than this. Okay, back to mediators. So the basis is under Minnesota Statute 518 and the rules of civil procedure. A mediator is a specific professional that the judicial officer may order without the consent of the parties, again, if there are no domestic abuse issues happening in the family. And their duties is to assist the parties in reaching a solution and an agreement that is going to be valid and long-lasting. So the children are typically not included in this process. They can be only if the mediator and the parties both agree. Typically, the duties is the two parties sitting down to talk. So the mediator is not a party. They have immunity pursuant to statute, and there's no exception in the limited statutory exceptions. Okay, I just stumbled over that. I apologize. They have immunity pursuant to statute. There are limited statutory exceptions where you can call a mediator to testify, but it's very, very rare. The whole purpose of attempts to mediate and resolve a case prior to a trial is so that the parties don't have to go to trial and talk about the issues and have lots of witnesses and testimony and have a very acrimonious, contentious hearing. The purpose of mediation is to be able to do that in a safe setting with a mediator, to have those conversations and to try and reach an agreement. And in order to do that, the parties have to be able to feel safe and free to talk about whatever issues are happening or going on. And that may mean making some admissions about their own deficiencies. And so in order to that to be a safe place where parties actually talk about all of the real issues, it's intended that the mediator cannot later be called. Things that are happening in that meeting cannot later be addressed through the trial process. We might try the same issues and talk about the same issues, but I can't use something against the other party that they said in there that I'm not able to get through other discovery means or that I don't already know. Mediators have no decision-making power. They don't typically make recommendations either. Their role is to help the parties to have a conversation. They might evaluate the positions of the parties depending on the type of mediation that they're having. So mediators can sometimes be used for those early neutral evaluation kind of process. And in those, if they might say, well, I think based on what you're telling me, the court is most likely to do this. Or if the parties ask and they say, we can't reach an agreement, what reality? Give me a reality check. What's a judge really going to do? They might make some recommendations or suggestions of what they think the judge might do or what's most likely to happen based on their training and experience to give the parties a starting place to have that conversation. When there's been domestic abuse in a family, it's often not best to use a mediator or to do this process. This is typically intended for parties who are able to go into a room together, sit down, and have a conversation. However, if a party really wants to, there's a way to do shuttle mediation where the parties are in two separate rooms and the mediator listens to one and then relays that information to the other party by going back and forth between the two rooms. Again, it's not typically recommended for domestic violence situations. I personally have done it after significant preparation and safety planning and stuff with a client who really, really wanted to have a conversation about their children, even though she had been abused. So it can be done, but just know this isn't primarily intended for that purpose. Nothing that they say or have is discoverable. They don't have discovery information from the lawyers or court case. They only have anything that the parties give to them, which is voluntary, and nothing that they have in their file can be used by the parties in court. They have no decision-making power, and the goal again is to use this whenever the parties think that an agreement is able to be made. And when the parties want to reach an agreement, this isn't intended for parties who are at each other's throats. This is intended for parties who both reasonably have ideas for what they think the divorce or the custody or parenting time needs to look like, but they aren't able to agree. And so this is, again, a safe place to have those conversations and see what middle ground they can agree on prior to going through a trial where there's gross things happening, like talking bad about each other, which not all divorcing people want to do. This is a contractual relationship, so the fee is set by the individual mediator. And again, if you have a fee waiver, most mediators are willing to do it on a sliding fee scale, or the opposing party, if they have more money, might be willing to pay for the mediator for both parties' fees. A parenting consultant is a person who is controlled under Minnesota rules of Civil Procedure 114.92. A court cannot order this unless the parties agree. This is typically a post-decree person. So after your divorce, custody, or parenting time has been resolved, and your order is final, this person is the person you would go to if there's a disagreement after that. So their duties are defined by the individual parenting consultant and the parties. This is a contractual relationship as well. So you're going to talk with them together and determine what kind of role they're going to have and what kind of authority they're going to have. Just one second. I want to make sure I'm on the right page of my notes here. Their role is generally to educate the parties regarding child development issues and to help with communication between the parties. So they can make decisions regarding any parenting issues in addition to scheduling issues. So for example, if one parent is not giving the child a prescribed medication during their parenting time, the parenting consultant is going to talk to that parent about why they're not doing it, why it's best for their child, and why they need to do it. So it's not just about scheduling issues. It can be about hygiene. It can be about medical stuff. It can be about school stuff. It can be about how attending your child's practice makes them nervous because they want to do everything best in front of you. And so when you're there, they're not able to enjoy their extracurricular activity. I'm just making stuff up now, but that's the kind of things I've seen them be used for in the past. So they're, again, not a party to the case. Typically, the case has resolved before they're appointed. And whether they can testify or have immunity depends on the court order. If they are called or subpoenaed, they must testify unless otherwise provided in the contract or a prior court order. So if you agree in your settlement for the custody matter that you're going to use a parenting consultant, that this is who they're going to be, this is what we want them to do, we don't ever want them to testify. If that's in your order, then they can't be called. If that's in your contract that you've set up with them, then they cannot be called. But otherwise, they can be called if you end up not being able to use them to reach an agreement, but want to go to court to modify an order. So again, their decision-making is also controlled by the contract. It's the best use of them and their decisions are for them to be binding with the right to review it with the court. So if their position isn't going to be something that both parties are going to agree to, it's kind of a waste of money to have them and use them. The purpose of them is so that you don't have to go back to court, that you have a person who's neutral, who does not have a relationship with either of you or your children, and who's making decisions and suggestions based on their training and experience, typically in child development, social work, counseling, something like that. They generally make recommendations to the parties, and they're also allowed to make recommendations to the court. So although they don't have to be binding unless your contract states that, they are going to be making suggestions and directions. Their goal is not to help the parties to have a conversation, but to resolve disputes between the parties. Again, generally their information is confidential, but it is defined by the contract. So they have access to what you say they have access to, and their file can be used for whatever you agree ahead of time that it can be used for. Unless the contract specifically provides that they have the authority to change custody, that is one thing they are not allowed to do. What they might be changing is parenting time or schedules or specific decisions between the parents, but they cannot change custody from one parent to another. They're most often used and best used when parents need assistance in parenting, communication, or ongoing decision-making regarding parenting issues. So if they have joint legal custody and they have to make decisions together, but they can't agree, that's a perfect time to use a parenting consultant. And it's prior to filing any motion or modification request or anything with the court. It's always post-judgment and typically for temporary issues. If you need to change custody, you're going to be going back to the court to do that. If there's significant endangerment or safety issues, you're going to be going back to the court to do that. This is typically for temporary issues that arise. Example, I want to go on vacation, but it's his parenting time and he won't allow me to go. I might go to the parenting consultant and ask them to make a decision about that. Can I go? I've offered this other week. He doesn't want that week. How can we resolve this so that my child can come with me to wherever we're going? Again, the fee status is going to be set by the contract, and each individual parenting consultant is going to have their own fees. Typically, these are paid much like an attorney is paid. So there's a retainer fee that's paid up front for a specific amount. And then as you use them, they bill you hourly and you get a bill which is taken out of that retainer amount. And then if your retainer gets below a certain amount, because you've used them so often, they will have you pay back into the retainer so that they always have money knowing that they'll get paid, which is also a reason for parties sometimes to get along and be able to reach an agreement without the parenting consultant because they don't want to keep paying in. But if they aren't able to, they know they have this resource. A parenting coach is different from a parenting consultant. There's no statutory or rule authority giving them, and a judicial officer may not order them to be a part of the case unless both parties agree. They're defined by the parent and the parenting coach of what their roles is going to be, and they work typically one-on-one with the parent to educate them about how to parent or get through the process. So sometimes they're called divorce coaches. They're there to help the parent deal with issues that come up as they're going through the process. I've never actually worked with a parenting coach, so this is new information to me as well, again, from the Minnesota CLE board who I borrowed this information from. They're not a party to the case. Unless there's a written agreement, they do not have immunity and can be required to testify in court. They have no decision-making authority that's binding on the parties. And they're typically going to be making recommendations only to the one parent that they're working with, not to the court or to the other parent. They're helping one of the parents through this process. Any discovery that documentation or things they may have in their file that can be discovered by the other party is going to be defined by the agreement. And their limitation, again, is that they're only working with one of the parties. So they're limited in not having all of the information. They only have the information that their client is providing to them. And they don't have all the information the court has, the parenting evaluations, the custody evaluations, the guardian ad litem. They're really just working with one parent, coaching them through this process. Typically during the process, but oftentimes also after the process to help the parent in working with the other parent in accordance with the order. So if a parent needs personal one-on-one assistance with parenting or with the legal process, that's when they're most often used, and their fees are set by the individual parenting coach. The last professional that we're going to talk about today is the therapist. Therapists are professionally regulated by their licensure and by the statutes that control each type of therapist. A judge may order therapy that a client enroll in, participate, cooperate with, follow recommendations of a therapist, even if the party doesn't agree. However, a therapist is not a party to the case and cannot be ordered by the judge to do anything. Their typical role is that they're providing therapy to one parent or the other, or they're providing therapy to a child whose custody and parenting time is being looked at through this court process, or to the family group. There's reunification therapists, there's family therapists, there's different roles that they can play through depending on what kind of therapist and what kind of licensure and role they have with the family. Therapists are mandated reporters and should talk with their clients about that before they start this process. But again, always something we need to remind our clients about. Therapists are not a party to the case, so they don't have a right like either parent or a guardian might to step in and have a role. Whether they have immunity depends on the court order. There's something called a safe harbor agreement, which is often used for therapists of children. The point of that is that the child can go in and talk with their therapist knowing that this is not going to come back to their parents. Neither parent has access to the file, neither parent can subpoena the therapist or require them to testify or take a position in court or to disclose their file, because the child needs to be safe to talk about their concerns about whatever parent they have concerns about without fear of it getting back to that parent or putting that parent at harm or putting the child at greater harm in a domestic case. However, if they are subpoenaed, they are required to testify unless an agreement like the safe harbor agreement I just talked about, or a contract similar to that, or a court order is in place preventing it or protecting it. If they're subpoenaed, they have to testify. They have no decision-making authority. They can, however, make recommendations as appropriate for the party that they're working with. So the court may say, client, party, provide me with what your therapist says they would recommend for you to do for next steps, so I know whether it's safe to start supervised parenting time with you or something. They can't make recommendations for a party they're not working with, and only make recommendations to the court when ordered or asked to by their client. Again, their discovery status is limited. They're protected by HIPAA and other forms of protection, including the safe harbor thing I talked about. They're limited significantly because they only have one side of the information. They only know what their client is telling them, and they don't know what they don't know. So it can happen that they might inadvertently become an advocate for the client and really be making suggestions or recommendations to the court based on what their client wants, which isn't their role. So you want to be cautious about that when using a therapist in a court case. It is appropriate to use them, however, when a parent or child has mental health concerns, chemical dependency, emotional difficulties, and that they are amenable to treatment, that a therapist is going to be able to help them with the issues that are not necessarily directly impacting or connected to, but are interfering with or exacerbated by the legal process. We know this can be a really stressful, difficult process for victims who often may have PTSD or other issues, and when they feel re-traumatized through the legal system, a therapist can be really important in helping them through this. Therapists also can be used to reunify an estranged parent and a child. We don't just plop kids back in parents' lives who they haven't seen for a while without a therapist helping to re-engage and develop that relationship safely first. The fees for therapists are often paid through insurance, but are always set up by the individual therapist, their office, or HMOs, whoever's handling that. So that was a really quick overview of a lot of different professionals and all of their different roles. It's common to have these people involved in our cases, and it's important that we have at least a general understanding of who they are and what they can do, what roles they have. If somebody does get appointed to your case and your client wants to know who they are or what they do, or there's some question that comes up, again, Standpoint is always here for you. We literally exist to help you and answer your questions. So if there's any questions now, I'm happy to answer them. We have about 20 minutes left for this webinar. If people do want to interact, I'm happy to do so. If there aren't any, please call us. My direct line and email are listed here, as well as our office number and main email.
Amy, there is a question around training around domestic violence and sexual violence. So all of these players that you were talking about, do you know if any of them are required to get any training around that topic? Or is that something that is mandated for them to do? Or is it mainly participatory?
So each of them is different. I know for sure that custody evaluators and guardian ad litems, not custody evaluators. I know that guardian ad litem specifically receive training about domestic violence. And I would have to look quick back through this. Just give me 1 second and let me see if I can. It is in the slides, but I just have to go through them again to remember which ones. And I'm sorry, I don't know off the top of my head which specific ones.
Okay, no, that's fine. What I can do, Amy, is maybe we can try to find the answer to that, and then I can post it on our listserv after the fact as well. So I know that it's a common question that people might have, especially when a lot of the participants and people we serve are experiencing domestic violence or sexual violence, and when there is family court happening, issues of custody, parenting time come up, and usually one of the parents have been abusive. It's
Mhm.
it is a question that advocates have in wondering, okay, the people that are doing these, um, parenting time evaluations and determining, who should have custody and things like that, like, are they trained in these topics? And so I think it's an important question, and we can look into it more and post it out on our listserv.
So I did find it back in my notes. The only ones that I actually have documentation about are the Parenting Time Expediter. They do have a required 40 hours of family mediation training and receive certified domestic abuse training, and the guardian ad litems do. As for the other ones, I'm happy to look into that, and like Ty said, that's a good idea to provide it out to the listserv.
Mhm. There's another question asking, is there any limitations to the people that Standpoint can serve? An example like the city of residence. And Amy, the answer to that would be we serve the entire state of Minnesota. So as long as it's a city that resides in the state of Minnesota, our attorneys can advise because they have licensure to practice in Minnesota. It does, though, have to be questions around someone who is experiencing domestic violence, sexual violence, or trafficking. Do you have anything else to add to that?
Just if they live outside of the state, but their case is in the state,
Mm-hmm. True.
then we could answer that.
Yes. All right. We can allow for a little bit more for questions, but I don't want to take up people's time. So, we are available Monday to Fridays, 9 to 4. If you have any questions about today's webinar or any other questions around any of the people that you are serving, please feel free to give us a call. I will upload this webinar onto our YouTube page when it becomes available, usually next week sometime. But other than that, thanks for joining us today, and hopefully you were able to get some new information. Bye.
Thanks for your help, Ty.
Mhm.
Bye, everyone.